Okay, well, hello everyone, and welcome to our April webinar. We're going to be talking today about navigating unfair contracts. And this is some legislation that affects many businesses, a lot of small businesses, in relation to what you can and can't include in contracts that you might do in business. Before we get into the content for today, a quick introduction to Sprintlaw for those who don't know us already. We're an online law firm designed for startups and small businesses. We provide fixed fee legal services. Unlike traditional lawyers, we don't charge by the hour. We always have upfront quotes and fixed prices. We operate in most areas of commercial law, from helping you set up your business, contract drafting, intellectual property protection, data and privacy, fundraising, employment law, and as we'll be talking about today, consumer and compliance as well. We have an optional membership. Most of our clients sign up to it. It's pretty low cost, about $800 a year, and you get access to unlimited quick consults with our lawyers, and a growing suite of self-service legal tools. There's an e-signatures tool in there, similar to what you get with like DocuSign, some free documents you can generate, and we also have a Taylor AI, Legal AI, which you can use to ask questions on Australian law topics as well. So check it out if you haven't already. There's a free tier if you just want to give it a go. We've been around for 9 years now as Sprintlaw. We're from Australia, but have expanded to New Zealand and the UK as well. Have a happy team of over 50 and love helping smaller businesses with their legals. So check us out if you haven't. And if after this webinar you are feeling like you might need to get some contracts updated, do feel free to get in touch. We offer free initial chats and consults on for pretty much any small business. And there's discounts running at the moment for getting contracts reviewed or updated for compliance with unfair contracts laws. So let's talk about the unfair contracts laws. We're going to be talking about exactly what these laws are. The law actually changed late 2023, early 2024. So we're going to be talking a little bit about what is in the new laws. Many of our clients have contracts that were written before 2024, which even if you got a lawyer to do, would need to be updated now, very likely, if it's your customer agreement. So we'll talk about exactly what's changed and what might need to change. For those of you that might have used an online template as well, or even had one generated with AI, as people do these days, uh, unless you use one of the latest versions, there's a good chance they also relied on the old laws. And so we'll talk a little bit about exactly what is what needs to be in the document. Otherwise, you risk breaching these laws, and exactly how it has differed to what most contracts said prior to the end of 2023. We'll then have some case studies of examples, and we'll talk about what you actually should do to avoid potentially heavy penalties. So that's kind of the agenda. As I'm going through, do feel free to drop questions using the Q&A feature on Zoom about pretty much anything I'm talking about. I don't mind answering questions as we go. It often adds color to what we're talking about, but also I'll leave a bit of time at the end to go through questions. So, what are unfair contract terms? Well, there is a law in Australia that applies nationally to all standard form contracts, with some limits on exactly who it applies to that we'll come to in a second. If this law applies to you, and there is a contract that you're issuing that is a standard form contract. By standard form, we mean maybe a terms and conditions people accept, or maybe it's a client contract that you give to your clients and you say, here are my terms, and they accept them. If they're not negotiated, or they're not presented in a way where they're meant to be negotiated, there are now requirements as to what you can do. And this is to recognize the fact that, as many people would know, increasingly in the e-commerce world, but in business in general, a lot of people just sign contracts without really knowing what they're signing. Obviously, for bigger businesses with lawyers on both sides that are negotiating contracts, they have a chance to understand what they're signing. But this is to recognize that for consumers, individuals, and also small businesses who are often in the same boat as individuals, people aren't reading those terms and conditions. So the law says, well, you can't sneak aggressive terms in there. And so, we have these requirements that the contract cannot result in a significant imbalance in the parties' rights. It can't be so favorable to one party, for example, the business issuing it, and unfavorable to the other. Um, uh, Imbalances must be there. I mean, you can have imbalances, but they must be there to protect the legitimate interests of the party that wants to rely on them. So you can have things that are, more protective to one party as opposed to the other, but it has to be for a legitimate reason, which again is not that clearly defined, but there's some examples of what that might be. Um, and yes, their contract terms are more likely to be unfair if they can cause significant detriment to the other party if they're relied upon, including financial detriment. So this is sort of what we're talking about, things in your terms and conditions that are really going a bit too far. And it's important to mention this because prior to these laws being updated, um, we did actually have an unfair contract regime, and we'll talk about that in a bit more detail. But it didn't result in fines and penalties. And so most lawyers who are writing contracts for their clients would have tried to protect their client as much as possible and would have structured their agreement in a way that significantly protected their client. So, for example, if you're a service provider, you're a consultant, um, or maybe you make websites or something, your client agreement, your service agreement with your clients, had you had that written by a lawyer prior to 2024, it would have just said, okay, I'm providing you with the service, I'm building this website for you. If things go wrong, it's not my problem. Or you'll have to pay me more if you want me to fix it. I'm not responsible if your website breaks and because there was an error in my code, sign here. Um, your lawyers might have written contracts structured in that way. Uh, Things like that are what we're talking about when we say that may be deemed unfair. And the stakes are a lot higher now because you can get fined if you have clauses like that, if that makes sense. What changed at the beginning of 2024 is these laws that kind of already existed but didn't really have significant penalties. Fines have been introduced, as I just mentioned, and they apply to a broader range of businesses. So, they apply not to everyone, but close to pretty much everyone who is using standard form agreements. So this is the definition of who it applies to. If you are using or signing, I suppose, a standard form contract, those terms and conditions, or maybe it requires a signature, but it's not one that requires negotiation. That's considered a standard form contract. Is the person that's signing it a consumer or a small business? And we'll look at the definitions of those in a moment. So it's either a business to consumer contract, B2C contract, or a business to small business contract, which, as I said, is a very wide scope. It's not. A lot of people think this just applies to consumer contracts with individuals, but yeah, as it says there, it also applies to business to small business contracts. And now, if the contract with the client was created before 9 November 2023, there is an exemption if it was signed before then, because obviously you didn't know that the laws had changed. But if it's signed after that date, it it will apply. And when we say created, the law doesn't care about what date you created your template. If you took clients on after 9 November 2023, you should have updated it from the law's perspective, so you could have fines and penalties if it's in breach of these terms. And just to explain what small business means, small business is not that small in terms of how the law defines it. It used to be, but the new scope is if one of the parties have less than 100 employees or makes under 10 million in turnover, they're considered a small business. So if your business is, or if you or your clients have 100 or fewer employees, or make less than 10 million, then you got to comply with these laws. So that's why I say it's the only category of transactions that are exempt are when large businesses are dealing with large businesses. But for most standard form contracts, these laws apply. And so again, this is something that has a very, very wide scope for small businesses and businesses everywhere, really. And this was the other big change, which is why I think it's high stakes. These laws existed before, these unfair contract laws. They've been around for many years, but lawyers still would draft contracts that were significantly balanced in one party's favor, because what we would write in the agreements, we would say, if any clause in this agreement uh, is uh, or we'd say we use language like to the maximum extent permitted by law, or we'd say if any clause in this agreement is found to be void or unenforceable, it will apply to the maximum extent possible. So lawyers would still have a go to make it very imbalanced, but they'd use language in there to say, well, we're not trying to breach the unfair contract laws. We're just trying to take it to the maximum extent that we can. And people may have seen those sorts of words in their contracts. The reason lawyers would do that is because previously, under the unfair contract term laws, if you had one of these overly imbalanced clauses, you wouldn't get fined. It would just be void if it was challenged in court. A court would look at it and say, that clause is too imbalanced. We're just going to imagine it wasn't there and still read the contract. So many lawyers would take the view, okay, well, we'll try and protect our client as much as possible, but worst case, it's just going to be void. And so we may as well have a go, but it's not like our client's going to be fined or suffer liability for having too aggressive a clause. And in part because of that practice, this is what the law has changed. And so if your contract has these clauses in it, and as I said, this is quite risky because a lot of people are using, online templates for their client agreement, AI generated documents, or maybe they had a lawyer write it, but it was before 2024 or late 2023. Now there's a good chance that your contract would have these aggressive terms because it was common practice to do so before then. And if they do, you can now be fined and suffer penalties. So there are penalties of up to 50 million for businesses and 2.5 million for individuals. And those penalties can apply each time the term has been agreed to. Now, it's unlikely they're going to fine a small business $50 million. And those penalties are really intended probably to be used to the maximum extent for large businesses, like a big bank or financial institution or insurer that has these kinds of clauses in their customer agreements. So there's definitely a focus on protecting consumers from those situations. But fines have been issued already for small businesses, not quite at that quantum for having these clauses. So if you really want to make sure that your contract does not have these overly imbalanced clauses in it, because again, if a customer sees it, decides to report you to the ACCC for including in your agreement, that can draw their attention to it, and that's where a penalty or fine can emerge. And yeah, I sort of just covered this, but it's not just a one-off fine. If you've taken 50 clients on and they've all agreed to the same terms and conditions, and each of them have unfair terms, that's 50 times penalties, if that makes sense. So the money can really add up. So again, the stakes are reasonably high. So let's talk about what are these actual terms. What do we mean by a significant imbalance in parties' rights? Well, we're going to look at a few very common examples that businesses are using in their agreements. One is a fee variation trap. Another is the one-sided liability, and the third is the termination clause. So let's have a look at the fee variation clause. So this clause is in standard wording in many agreements, and it's in breach of these laws pretty much. We reserve the right to change the fees from time to time. We will notify you in advance if we do this. Let's say you got a customer on a software subscription, or even if it's a service retainer with you. If you have a right to change your fees and you don't allow them to cancel, um, that's seen to be an unfair contract um, term. Now, that doesn't mean you can't change your fees over time. Of course, businesses need to raise their fees, change their fees, inflation, price changes. You can do that. You just have to have a procedure for notifying the clients with enough advance notice and giving them the right to terminate um, uh, and if they don't want to proceed. Um, and so you can imagine here, if you got the wording on the left, like technically that allows you to just say, okay, it used to be $100 a month, now it's $200 a month. Sorry. That wasn't a practice people were doing that frequently, but what people were doing was they'd have people um, on uh, long-term contracts and then give them very little notice for a significant fee increase. And so while the client was being given the right to cancel, um, practically it was very difficult for them to cancel um, very quickly because they weren't given enough notice. And so there was sort of examples and cases where this right to change the fees for someone that set the fees was seen to be unfair and cause these sort of imbalanced outcomes. So again, what makes sense for your business depends on your business. On the right, we've said here, if we do this, we'll provide you with reasonable written notice, at least 30 days, and you'll have the right to terminate immediately. Now, depending on what your business does, 30 days may not be long enough. If the business is heavily reliant on your services, on your software, on whatever it is that you're providing, and you want to increase the fees, and you only give them 30 days notice, that could be seen to be unfair because they would not have any realistic option to transition off in 30 days. So you might need to give them 60 days notice. So when we're drafting these, we consider them on a case-by-case basis for our clients. But in many cases, something like this would be a more balanced clause. Yes, we can still increase our fees, but we just have to be reasonable about when we do it and how we inform our clients around it. So this is a liability example. So here we have the example of a landscaping contract which allows a landscaper to avoid any liability for damage to a client's property which occurs due to their own negligence. So we have on the left the clause, any damage caused by the client's property will not result in any liability on the part of the landscaper. The client fully assumes all risk of damage and loss related to the landscaping services provided. So, you've hired somebody to come do work on your property. They're saying, okay, I will do this work, but if I break something, damage the property, sorry, too bad. You agreed to my terms and conditions, and that's the risk of using me. And again, many service provider agreements had this very aggressive liability clause in it before, i.e., like, um, take it as it is, and I'm not liable if things go wrong. And if you're a service provider, you often want a clause like that in the agreement because, you might be accepting a few $1,000s for a job, and if you caused $1 million worth of damage, you would not want to be liable for $1 million for a few $1,000 job. So it's understandable why service providers don't want to have liability, particularly small businesses. But this has been sort of deemed a pretty clear example of an unfair contract term. So a potential new clause you have on the right is the more balanced version of liability clause. The landscaper will take all necessary precautions to prevent damage to the client's property. Should any damage arise as a direct result of the landscaper's negligent actions or omissions, the landscaper will be responsible for rectifying such damage at their own expense up to a maximum liability amount of $5,000. So you can see in this example on the right, we've still got a protection for the landscaper from liability, but there's a few more balanced aspects. First of all, the landscaper is agreeing to do their best to not damage the property, which again is already much more reasonable. Then we've said, okay, the landscaper will have liability, but only where the damage is a direct result of their negligent actions or omissions. So, if the landscaper I don't know, there's a they don't finish on time due to like uh, arriving late, and then there's some rain, and then because they didn't finish on time, something else happens, which leads to something else happening, and then the whole property is damaged. If it's a very indirect cause, the landscape is not going to be liable. So we're creating a narrowing of the circumstances in which they're liable. If they actually do something that causes damage, a direct result, then we're going to have liability. So that's a much more balanced way to protect the landscaper. It's not saying we'll have no liability, but it's also not saying we'll have infinite liability. It's only for stuff we directly caused. And then we've put a cap. We've said, and the most we'll ever be liable for is $5,000. So, you know, a cap is allowed. You're allowed to say, I won't be liable for more than X. The cap, though, has to be commensurate to what the service is. So, if the landscaper said the maximum I'll be liable for is $1, that's pretty much saying I'll have no liability. But it doesn't have to say $1 million if that is not tenable for the landscaper's business. If the landscaper says I can't be doing jobs every single week in my current business, taking on $1 million of liability at my current price point, that's a very reasonable argument. And the guidance notes in the unfair contract laws um, talk about a lot of factors in considering what's reasonable in liability protection. So we often look at doing a 2 times a refund is kind of the maximum liability, and that seemed to be reasonable. In some cases, you might do just a refund. So if the landscaper was paid $5,000 and they say my maximum liability is $5,000, that might be a bit too narrow, depending on, if landscaping is a higher risk activity, that could still be seen to be a little narrow. But it's often a multiple of the usual fees that person gets paid for their services, and that's what you're going to cap your liability at. Um, so that gives you a little bit of a sense. You can still protect yourself for these standard terms. You just can't say, oh, I'm going to have zero liability. It has to be a reasonable protection for your liability. And again, there's some judgment required in exactly what that's going to be. Case study number 3. We have a catering services contract that imposes fines on clients for cancelling their catering services before the contract term ends, while permitting the caterer to terminate the contract at their discretion without incurring any penalties. So this is common. Service providers would say, if you cancel, and we get a lot of questions from our clients about this, if you cancel with very little notice, you're going to have to pay me a cancellation fee. Because, I couldn't take any other bookings on that day, and I got everything ready. And in the case of catering, maybe this person had already bought all the foods, et cetera, et cetera. But if I cancel for you, that's your problem, sort of thing. And again, there's a few examples that have been challenged with the ACCC of cancellation clauses and penalties for cancelling. And so there's some good examples of what is considered reasonable in a termination context. And this structure we have on the right is one of the most common, more compliant clauses we see for these kinds of, let's say, event contracts. If a client wishes to cancel prior to the end of the term, a cancellation fee will be imposed as follows. If you give me lots of notice, it won't be as much, but if you give me less notice, it will be more. So X% if it's more than Y days, and then Z% if it's less than Y days. So this makes the fee more referable to the amount of the inconvenience that the cancellation causes the caterer. It's just not a flat 50% cancellation. It says, well, if you give me more notice, I have a chance to, book another client, and then I may not have any loss, if that makes sense. So what the X, Y, and Z are depends on the business, what you're doing, the nature of the order size, et cetera, et cetera. It has to be reasonable in the circumstances. Like if it was, 100% fee if cancellation is less than 360 days notice, well, that's pretty similar to what we have on the left. So they have to be set reasonably. Now, if you're not doing event-based services, and this may be the wrong structure for your cancellation clause, but many of our clients have clients on lock-in, 1-year agreements, um, and they obviously don't want to be required to give, if they've sold an annual contract, they don't want to be required to give um, a refund if the client changes their mind after 2 months. It would defeat the purpose of the annual contract. But that said, if you don't structure your lock-in contracts um, in an appropriate way, and they impose hefty cancellation fees, um, which bear no relationship to the amount of loss or inconvenience suffered by the business, there's a risk of them being unfair. So, for anyone who's got any kind of in advance payments or lock-in contracts or lock-in retainers, you just want to be careful about your termination clauses because, um, again, if they're seen to be too aggressive or unreasonable, then this is where the law can step in and say that they're sort of unfair. Um, now, we also have on the right, if the caterer seeks to terminate the contract without valid reasons such as force majeure or non-payment by the client, the caterer will refund the client any prepaid amount. So again, if the caterer is cancelling in this case, they've got to give a refund unless there's a very good reason. For example, the client is sort of not paying. So, and again, there may be circumstances where it's reasonable for the caterer in this scenario to keep some of the amount. Let's say it's an event catering. There's a weather event, so the event is called off, but the caterer was prepared and ready to go. Or there's a weather event and the client wants to proceed, but the caterer thinks it's unsafe. The caterer may have the right to cancel and may not have to give a full refund. So there's different ways to structure this clause. And again, the whole time you've got to be thinking about the balancing of the rights in this agreement. Here we have more of an emerging issue, which is these automatic renewal clauses. And many people here will be signed up to subscriptions where renewals are automated. And many of you might be running businesses where you have subscriptions that automatically renew at the end of the term. So this is a difficult one because for many businesses, the automatic renewal is very operationally convenient. Um, it's a great way of retaining a revenue with customers. If you have to go and contact every customer before they renew and get their explicit permission, it may be significantly inconvenient for your business. That said, because it's become more and more of a common practice of people getting billed, not being able to get their money back with unexpected charges, the ACCC has put out a little bit of guidance saying that these things may be considered unfair contract terms. There was an example from a couple of years ago with Crisco Hampers, a membership agreement that automatically renews at the end of the initial term without explicit consent being obtained, um, can make it difficult for them to cancel. And Crisco Hampers wasn't a gym case; it was a Hampers case, as the name suggests. But it sort of had those sorts of terms where the ACCC said this automatic renewal, where consent wasn't explicitly sought, was found to be in breach of the unfair contract terms. In the past, you'd have these clauses that said, and again, these may be in people's terms and conditions, at the conclusion at the end of the initial term, this agreement will automatically renew for successive periods equal to the initial term. So someone signs up to a 1-year contract, we tick over at the end of the year, it automatically renews for another year, and you're locked in. You can't get your money back if you didn't know that it was renewing, unless you provided um, uh, 5 days advance notice that you wanted to cancel. And so people would, miss the 5-day deadline. The contract renews, and the supplier says, "I'm sorry, but you should have told us before. It's too late. Now it's renewed." So these are sort of these like subscription traps. Clauses like that are increasingly likely to be found to be non-compliant. That doesn't mean you can't do automatic renewals, but you need to be careful about how they're structured. Maybe having a grace period, very clear reminder notifications, and a more balanced process if you want to automate the renewal. So at the conclusion of the initial membership term, the membership will automatically renew for successive periods equal to the initial term. However, members will be provided a grace period of 30 days from the start of the renewed term to cancel their membership and get a full refund for that term. Here is where you can contact us for the refund, and it'll be issued within a month of you asking for it. And we'll also give you a reminder before. So we've still managed to have an automatic renewal with the clause on the right, but it's much more balanced. We're giving a grace period if they miss it. We are sending reminders. We're making it very clear. And so if the client in this case still misses the notification, but they were actually sent it and misses the bill and realizes 3 months later that they had a service, it could be reasonable for the supplier to say, well, I'm sorry, but you were given ample notice. This is the terms that you signed up to at the beginning, and we've incurred costs as a result of you renewing. So in those circumstances, you can say that's on you, the customer, or at least you're more likely to be able to. But if it's too aggressive in the way that it works, it can breach these laws. So hopefully that makes some sense. We get a lot of questions about this in particular, the renewal clauses and how they work. And a lot of businesses want to incorporate them into their agreements. And it often requires quite a bit of discussion with our lawyers in terms of structuring this clause in a way that achieves the business goals, but also doesn't have too high a risk of being an unfair automated renewal term. So hopefully those examples give you a little bit of a flavor as to what an unfair contract term is. In terms of what you should actually do to make sure that you're not going to get fined or have penalties for using these terms, I would suggest you get your T's and C's properly reviewed by a lawyer, particularly given the level of nuance and grayness, if you will, around how these clauses are interpreted and enforced. For your customer agreements, in particular, which can be your most important contracts as a business, if you're using them all the time with your customers, it does require a little bit of discussion, workshopping, and nuance to get the drafting right. So if you're using a template or your contract hasn't been updated in a few years, or you've DIY'd something, I think it's a bit risky. And I would very, very much suggest that you get them reviewed and make sure that it's compliant. And a lot of it will be not necessarily recreating your entire contract from scratch, but it will be zooming into particular clauses if you already have one, discussing with you what your business goals are, what complaints your customers are likely to have, and what you can live with, and rewording your clauses so that they are more balanced. You also might want to set up some compliance processes, understanding what the risks are with your customers. If your contracts become more risky for you, which they may have to if you're a service provider and you want to have a compliant contract, which you all should, you need to therefore think a little bit more about what customers you take on because they're going to have more rights. And so what we have seen some businesses do is they've relaxed their T's and C's, which they had to do, but they've just been a bit more careful with the customers they've taken on, and also made sure that they making sure their customers are aware of how their terms work. One of the things with unfair contract term laws is they work in association with the more general Australian consumer laws, which also apply to business-to-business transactions if they're small businesses, and under which there's laws about misleading and deceptive conduct and consumer guarantees and rights to refunds for businesses. And so it's not just about the terms and conditions in your document, it's also about how they're explained to your customers. And so if your customers are misled as to how they work, if they do have, for example, the right to cancel their subscription, but you're saying, oh, it's lock-ins, no cancellations, verbally or over email, that can also lead to fines and penalties under some of these other laws because you're misrepresenting how your agreement works. So you not only have to get the terms and conditions right, you also have to understand them and make sure that your customers are understanding them. It may be a good idea to consider getting your customer agreements reviewed regularly. Whether you can afford the legal review will depend on your budget, but once a year is not a bad cadence if your business processes are changing. If your business doesn't change at all, then it may be okay to use the same agreement for multiple years. Um, but typically changes to processes happen, and so your terms and conditions might start to drift from how your business actually works, and you just want to make sure that it's all tightened up and compliant with these laws. And again, the law's changing a lot in many different areas of law, from privacy to employment and so on. So in general, an annual review is a good idea. And finally, anyone who's customer facing in your business, if you have employees that are talking to customers, getting them to sign the agreements, they need to have at least a basic understanding of how this works, what your terms say. Because again, a very common issue is that the T's and C's are done correctly by the lawyers, but when employees are actually getting them signed and questions are being asked, they say the wrong thing or they mislead the client as to how it works. And they don't know how to respond to increasingly aware consumers of their rights. And again, in an age of large language models and AI, the chance that a customer of yours takes your terms and conditions, puts them through one of those tools, and says, "Tell me what clauses break the law," it's much higher. And we're seeing that happen with our clients' clients. They're receiving emails saying, "Hey, your terms and conditions are wrong. They have these clauses in them that breach the laws." Now, sometimes those reviews are rubbish or don't make sense, and they can be argued against. But the probability of a genuine issue being picked up is increasing, and so being making sure that your terms and conditions are defensible and airtight, I think, is important. So that was the end of the kind of content. If people have questions about anything related to your contracts, I'm happy to take them in the Q&A. I'll stick around. If you have questions about particular clauses that you're not sure whether they would be unfair or how any of this works, do feel free to drop them into the Q&A. Okay, maybe we have no questions. A very thorough presentation. Okay, we have one here from Frank. Confidentiality agreements always concern me. What traps exist with these? Yeah, that's an interesting question. The unfair contract laws would definitely fall under this regime. And so, well, there's a few different laws around confidentiality agreements, because there's also some new law employment laws around whether you can ask staff to sign confidentiality agreements, and some of those NDAs that were used in the workplace becoming unenforceable. But that's sort of a separate issue. In relation to just NDAs done in business, you're asking a customer to sign an NDA or a supplier to sign an NDA before you share information with them. Some of the same logic that I just covered applies. If the agreement is too one-sided, it says, you, the client, are bound by confidentiality. You can't tell anyone anything that you learn in the service, but the service provider is not bound by the same level of confidentiality. That can create an imbalance in the parties' rights. Anything I tell you, you have to keep secret. Anything you tell me, I can tell whoever I like. That kind of one-sided NDA, there's a risk that that's going to be seen to be an imbalanced NDA. Mutual NDAs, which are more common these days, are a way around that, where both parties say anything we tell each other in this relationship is kept confidential. You can have a one-way NDA when the scenario permits it. For example, if one party is really the only one sharing the confidential information and the other party is just the recipient, then in that circumstance, it may be just reasonable because it doesn't cause an imbalance in the parties' rights. In fact, it evens them out. I'm sharing confidential information with you on the basis that you keep it confidential. So we'll always turn on exactly what's happening, what's being shared, and what's being discussed. And in a true one-way sharing scenario, you could avoid that imbalance risk. The other one would be the definition of confidentiality. So, some NDAs, confidentiality agreements, everything under the sun is confidential. Um, if one party separately finds out about the information from another source, there's always a question as to whether they're bound by the NDA. Trivial information or non-sensitive information or already public information, if that's being included as confidential information and being used to overly restrict the autonomy of an individual, basically in the way that you're defining confidential information, that could also be seen to be excessive and imbalanced. And then there's the time period. Is this going to be a 10-year confidentiality clause where you can't say anything to anyone for relatively little payment or whatever it is, or is it actually very sensitive information? So those are the kinds of dimensions. How broad is the confidentiality? Is it mutual? How long does it last for? And whether that's appropriate, like everything in unfair contract terms, turns often on uh, exactly what the situation is, rather than it being a kind of general answer. Aaron said the problem with software is companies sometimes make it difficult to cancel auto renewals, which could relate to the ability of the consumer to navigate the software. I mean, that's a great point. And this in the US, there's some laws that have come out recently specifically targeting softwares that have complicated interfaces that make it difficult to cancel. There's, if people want to Google the words dark patterns, you may not have heard that term before, but this is a word that's emerging to describe um, user experiences in software that are intentionally designed to make it very hard for customers to cancel. There's like 10 clicks they've got to go through. It's hidden in an area that they can't find. Support doesn't respond quickly, et cetera, et cetera. Setting up a process, I mean, that could be very profitable for businesses, but it's obviously there's ethical concerns and potentially legal concerns around these auto renewals. Australia doesn't have such clear laws on these dark patterns, so there isn't a law that says if it's hard to cancel, it's automatically unfair. But the ACCC have actually put out some specific guidance warning software companies of these practices of having difficult to cancel subscriptions and saying that they will be considering whether these are unfair contract laws, unfair contract terms, or really unfair practices rather than unfair contract terms, because it may relate more beyond the terms and conditions and actually to something a bit more akin to misleading and deceptive conduct. I expect we may have some specific laws for this specific issue at some point in the future. Um, but even if we don't, if you are on the customer side and you've got a vendor and it was really hard for you to cancel, there's a good argument that you should write to them and say, "Hey, I want a refund. I was tried to cancel and I couldn't figure it out, and I think this is in breach of the Australian consumer laws and some of these unfair contract terms." So there is some legal protection for what you're describing, Harren. It's not black and white, but it's something a lot of people are talking about. A question here. Early termination fees are quite interesting. What are your thoughts on annual fixed term agreements? If a consultant is retained for a year and a client terminates that fixed term early, what are considerations in making this more balanced or incentivizing clients to stay for the year? What justifications or evidence would a consultant provide to prove their losses? Yeah, great question. And this exact question is actually, we spend a lot of time with clients discussing this point because many service providers are wanting to retain clients. But obviously, a lot of the ideas that they'll present to us will say, well, that I can see why that's good for the business, but that does create this unfair contract list. So the balance is important here. And there is some guidance from the ACCC on what they consider to be balanced and unbalanced in relation to these annual type fixed term agreements. So on their website, I think there's a few examples of what they consider okay and what isn't. But of course, it's very dependent on how your business works. So, having like for example, a non-lock-in and a lock-in option, and providing a discounted rate for the lock-in option, again, when the customer signed up, they now knew what they were signing up to. So you're more able to lock them in if you actually have two choices that are explained to them. So oftentimes businesses will have the two choices. If the only way you can work with a supplier is through the lock-in annual agreement, then that's different to if you said, well, I gave you a better deal because I had the certainty of you being locked in. So that's one way, even just in your business operations, to make it more balanced. And that's a legitimate consideration, is whether there were other options. Um, the cancellation being tied to the how early in the retainer they cancel. Again, if you've got a cooling off period of like, if you sign up but you change your mind like in 2 days, I'm not going to charge you for the full year. But once you make it past 30 days, we're now in the 1 year scenario, and I'm working on the basis that I need to charge you for the full year. Can be more reasonable. That said, if it's the case that you've got your 30-day clause, it's a service-oriented retainer, and on day 32 the client cancels, and you try and charge them the whole annual fee when the labor cost to you is going to massively be saved because you don't have to do anything. Um, Even with all those protections, it could be seen to be a little unfair and unbalanced. So that it still gets a little bit grey depending on what it is that you do. If genuinely you're going to be out of pocket because you've scheduled the whole year based on this contract, I don't think the law will have any problem with you charging the termination fee. It reflects your actual losses. But to the extent that you're charging, and you really are making a big saving from the cancellation, it becomes a little more difficult. So the solution is often just a really well written clause and processes around that, and it can be done. You just need to be careful, and there's not really a one size fits all answer because it depends on your business and what you do and how it works. Um, a few good questions coming through. What about an external MSP IT? Initial project states 6 months, but it's silent on renewal. They're saying it automatically renews on a 6 month basis and have not been performing. Are these unfair terms? Could we break earlier without penalty? I obviously can't comment on that specific agreement without us seeing it. And again, feel free to reach out to our team if you'd like us to review, because a lot of it will turn on exactly what it says and about renewal, and there can be sentences in there that may mean things that. But if it were the case that you have a contract that just says it's a 6 month term, it doesn't say anything about renewal, and then they just try and say verbally that it automatically renews, unless they can show there was some agreement for it to renew, or whether in writing or implicitly, um, the presumption will probably be that it does not automatically renew because, again, under all of these principles, um, you would have had to have been told in advance in the contract what was happening, and it would have had to be reasonable for you to renew. So on those high level facts that you're sharing, in general, that does sound like a scenario where you'd have a argument for it either being an unfair term or potentially being able to break. But again, yeah, reluctant to provide you with an answer without actually looking at the contract because it could be different depending on what's in there. So I'd get that checked. Um, is it okay to be asked as an LMS provider to draft B2B supplier for terms for their LMS platform? Is there any duty that the company offering the service has to draft the terms given their business benefits them for a future affiliate license fee? So uh, I'm not 100% sure what you're asking. Are you asking whether and I assume by LMS you mean the learning management system, you're being asked to write the contract for your client, or your client's asking you to write their client contract? Maybe if you can clarify that with a follow-up question, exactly which terms, I can provide an answer to that one. Another question here: is it reasonable to expect software not to use um, data without your authorization? Um, that's um, that's interesting because that obviously today we're talking about unfair contract terms laws. That touches a little bit on privacy laws, um, which are a kind of separate area of law. Uh, in general, for like cloud software, um, when you sign up to a cloud software, um, you will be agreeing to their terms and their privacy policy. And often their privacy policy will say, you're going to be loading your data into our platform. We won't like use it to contact your customers, etc., but we are allowed to store it do analytics on it, um, uh, use it to debug issues that you may be facing when you raise support tickets. And by signing up, you agree to those uses of data. That's often required under privacy laws and can be also required under these unfair contract laws. So, depending on what they're using it for and how clear they made it, they can use it. And I guess they would have your authorization in that case. It wouldn't be without your authorization. If they start doing things with your personal data that you didn't give them permission to do, and it wasn't in their privacy policy, um, then that would be a potential breach of, well, actually, privacy laws, to which there are exceptions, but in general, that's kind of the relevant area of law. So many times, if you actually read the privacy policies of software companies, they're very, very broad. And so when you say without my authorization, you may have authorized without realizing. Um, but yes, it's they have to, under most privacy regimes globally, the software vendor has to get permission from an individual before they can use their personal information, which is often done through the privacy policy. Maggie said contracts already past the initial 6-month terms, been rolling for a few years now. Yeah, look, it's complicated in that case because there's something called acceptance by conduct, and so an argument could be made that if it's been rolling and you implicitly accepted it in writing for a few years, then you are actually bound by the terms. But also, there's uh, often strong arguments to say, well, it was never in the terms and conditions, and we never agreed to the 6-month term. So I would get a little bit of advice on that situation and see where you stand. But it does sound like you may have some grounds there. Um, Frank said, do these laws vary from state to state in Australia? These laws I covered today are national laws. Individual states have some other overlapping laws that are a little bit more specific. For example, New South Wales, there's some fair trading laws and so on that cover how trading can be done in New South Wales. But in general, if you're compliant with these laws, you are covering many of the requirements of the state-based laws, and these apply to all Australian businesses. They're not state-based. Um, Another question: if I find that I go back and forth with my suppliers all the time about one-sided indemnities, I understand one-sided blanket one-sided indemnities against all forms of losses are a UCT risk. But what are your thoughts on one-sided indemnities in relation to very specific risks, such as breach of third-party IP rights? Yeah, that's a good question. So it depends on the circumstances. So yes, oftentimes suppliers um, will want to uh, not accept indemnities for everything, but if your supplier is doing something that is very high risk for you, but you're giving them access to extremely confidential information, or you're getting them to write some new software for you that, there's a risk that they could steal other parties' stuff. It can be reasonable to ask for a one-sided indemnity for sure. And the more specific it is, the better. And the more that specific risk is tied to a genuine concern under the agreement, the better, if that makes sense. And so a lot of, again, what we do in these very same negotiations you're describing, where one party, wants and is worried about a legitimate concern, and the other party says, "Oh, well, I'm not indemnifying you. That's too risky for me." We do exactly what you say. We try and narrow it to be more specific, and we make sure that what it's being specific about is a genuine concern in the transaction. Like, obviously, you can pretend it's specific, but then write 600 specific risks and it basically becomes broad. That's not going to work. But if it is a genuine concern under the contract, depending on what it is, um, it's reasonable. And again, I think in the ACCC guidance, they specifically call that out. They don't say all indemnities are bad. They just say indemnities have to be carefully justified in relation to, why they're being included. So yeah, it's a good question. And I think the answer is what you're alluding to. Just be specific and make sure it relates to what the contract does. Okay, question here, clarification. I'm being asked to write the B2B agreed terms by the entity that used for my business, and that will flow into my CSA. All terms are currently silent and not comfortable to offer my clients without privacy cessation tools. So So um, it's the contract between um, your customers and you, but you're being asked to write it, or is it the contract between your customers and their customers? Um, Yeah, maybe we need to take that one offline because I don't fully understand the scenario, but I can maybe attempt to answer. Like, if you're being asked to write the terms and conditions for their platform's users, so you're providing a software, and they say, well, could you write my terms and conditions for my customers as well? Um, that is risky for a few reasons. First of all, if you're not a lawyer, you generally don't want to be giving terms and conditions to another business for their use. Now, there are exceptions to that if you have clear disclaimers that it's a template and advise them to get it checked by a lawyer first before using. There are many businesses out there that provide templates, but you've got to be very careful. And certainly, if you're drafting personalized terms and conditions, that's where it starts to drift into legal advice. So, in general, I would provide customers with a template and then at best, and then ask them to get it reviewed themselves. Um, so I think that's what you're asking. But if I've misunderstood, yeah, do feel free to reach out to our team. Um, okay, well, I think we're just past the hour, so those were some good questions. Thanks so much, everyone, for attending. We'll do another one of these in a few weeks on a different topic. As I said, feel free to reach out to our team if there's anything you need help with. Otherwise, I'll see you all next time.